Welcome to the National Credit Awareness and Resolution Association podcast at NCARA.org, your source for navigating debt repayment challenges during tough economic times. Today we'll explore how small business owners can more effectively use Creditor Tools, specifically bankruptcy. NCARA aims to bridge the gap between debtor and creditors as a paradigm shift allows debtors to propose their own repayment solutions. Let's get started. Bankruptcy. When a bankruptcy petition is filed, an automatic stay prohibits creditors from taking any further action to collect on their debts. This stay will remain in place until the debtor's assets are released from the estate, the bankruptcy case is dismissed, is discharged by the court, or the court approves lifting the stay. Debts owed to creditors are assigned to classes. The first class of creditors are priority creditors. They are to receive payment prior to other creditors. If there's no equity in the debtor's estate, the court is likely to terminate the automatic stay, allowing the creditors to seek repayment and liquidate the collateral. A trustee will be assigned to administer the affairs of the debtor's estate. He will control the disposition of asset sales, payments, and ensure there are no preferential transfers to creditors taking a security interest in an asset who may have taken certain actions, say 90 days prior to a bankruptcy filing, or 1 year for an insider. Bankruptcy petitions are also either voluntarily filed by the debtor or involuntarily filed by any creditor. Involuntary filings are filed where the debtor is considered to be insolvent by the creditors and where there's an expectation the assets will be sold to repay creditors. While still under the bankruptcy petition, a debtor could reaffirm certain debts with creditors and resume payment, for example, a mortgage or auto loan. Let's look at the different types of bankruptcy, starting with a Chapter 7 bankruptcy. Chapter 7 is where the debtor's assets will be liquidated. It involves a trustee who will sell non-exempt property and utilize the cash proceeds for payment among the debtor's creditors. Once the debtor is discharged, he is no longer legally responsible or liable for the debts listed at the time of the bankruptcy petition was filed with the court. Consumers and businesses both file Chapter 7 petitions. It's possible their other chapter petition filings to restructure their debts will be converted to a Chapter 7 filing for non-payment. A Chapter 11 bankruptcy. A plan that is intended not for liquidating assets, but to reorganize debts and repay them from future cash flows. The restructuring results in there being an approved plan of reorganization, voted and accepted by the creditors, that will outline how each creditor will be repaid. Chapter 11 petitions are generally utilized by business entities. A Chapter 12 bankruptcy. A plan that is designed for family farmer debtors who have a regular stable annual income tied to the farm operation. Its primary objective is to reorganize farm debt that aligns up with the value of the collateral, and there's an expectation that the farmer debtor will be able to make regular payments under the repayment plan. A Chapter 13 bankruptcy, a plan that is generally filed by individuals whose wages are used to satisfy unsecured and secured debts. The repayment plan is a new contract between debtors and creditors where secured creditors are entitled to vote. A majority vote will bind the minority creditors to the plan. Repayment is expected to be at least 3 years and possibly up to 5 years. In a Chapter 13 petition, creditors are expected to receive more than they would if the debtor's assets were sold and the proceeds were paid to the creditors. Importance to you. Bankruptcy is an expensive and time-consuming pain in the rear end for all the stakeholders. It seems to be a measure, or should be, of last resort, or an emergency undertaking where there are no better alternatives. A bankruptcy petition should be a rare occurrence and only for cleanup purposes. Bankruptcy is the ultimate failure of the debtor and creditors to come to a suitable resolution in restructuring debt repayment. Hard heads may have prevailed in repayment negotiations where the creditor was unwilling to work with the debtor because of bad feelings between the two parties. It's like any situation between two people who can't stand each other because of some offense given by one or the other, and then the other being able or unwilling to make any sort of concession to satisfy the other and come to an agreeable solution. It's where creditors will gladly spend good money after bad and put or force a debtor into bankruptcy and not care otherwise. This is too often just nonsense and ridiculous. Debtors can offend too. It may be very well that a debtor has offended the creditor by being unwilling to provide certain financial reporting when it was due. Why? Because the debtor is fearful and doesn't know what he's doing? To a creditor, this is terribly offensive, as it shouts out that the creditor that the debtor has no integrity, has lost his character, and is even dishonest. For why wouldn't a debtor be honest and provide detailed financial reporting when it was due, as he promised when he signed the promissory note in the loan agreement? Maybe the creditor is right. The debtor should have complied with his promised end of the agreement and been better prepared to negotiate and even propose his own repayment strategies short of having to file an expensive bankruptcy petition. But then again, creditors can be jerks too. Well, for one thing, it may be that the debtor perceives the creditor as the one who is completely hard-headed, unreasonable, an ugly jerk. You get the picture. Perhaps the creditor has been insensitive to the debtor's financial circumstances, won't listen, is offensive, demanding, and only wants his money back like yesterday. The creditor's demands may have been threatening to the debtor. So who in their right mind would want to even talk to that guy? Maybe the debtor is right. The creditor should have stopped treating the debtor as a number and more like a human being. A workout modification is generally much better. By now you should start to see and appreciate what can happen in a workout situation. If nothing is done, each stakeholder will be constantly fighting and becoming more frustrated with the other, and they'll end up in an unwarranted, expensive bankruptcy proceeding. An accelerated default can be a death knell. Keep in mind that loan documentation will generally include that, upon default, the entire balance can be accelerated where the full balance is due and payable. It would be like a loan maturity date was moved up to the present time. Upon default, there's also usually a default interest rate, which can be as much as 3% higher than the normal interest rate, or much more. If you had an intention of trying to cure the default, say by making up the missed payments, it is possible that because the entire loan balance was accelerated, the full payoff would be due and payable to cure the default, not just the missed payments. Bankruptcy is likely in that event unless you can sweeten the negotiations. Feel the burden of the debtor. The name of your business is on the promissory note, along with your signature. You likely signed an unlimited personal guarantee. You are the one who promised to pay, not the creditor. The creditor was the one who took the chance and lent you the money in good faith. He just wants it back. So you, the debtor, will do something new and different starting today. You will take a little time and pay close attention. In other words, take full responsibility for your debt repayments if you haven't already. You will come up with debt repayment solutions that enable you to repay the debts as best you can. That means being completely honest and forthright in all your negotiations with a creditor. This will include accurate and timely financial or other required and requested information. Not only can bankruptcy be avoided altogether, but the best repayment plan will likely be realized. We live in a period where that's all anyone can ask, really. Fight for your best repayment plan, and if all else fails, then do what you must have to do. This short ad is sponsored by the Debt Crisis Problem podcast. Attention, listeners. Please join us at tunabudget.com to tune in to the Debt Crisis Problem podcast. where in plain English we discuss the 20 risks that could soon fuel a serious economic downturn. We explore critical risks that could trigger economic downturns and offer practical insights for navigating financial uncertainty. Join us today for thought-provoking discussions that encourage transparency and awareness. Subscribe now to stay informed and ready for whatever comes next. Build a bridge with your creditor or fall off the bankruptcy cliff. Bankruptcy is very expensive, and you should avoid this ruinous experience. The creditor will likely recover, if not all of his money, over a reasonable period of time as your financial condition warrants. You must fight for what is in your best interest too, in terms of repayment timing, the terms, and the conditions. This is your moment, and you need to do your homework. You need to understand what the creditor understands about your financial condition and situations. You have to stop, take some time, and learn to appreciate or see or speak the way the creditors approach workout loans. Imagine yourself in financial trouble. How does the creditor see its interest in your company compared to your point of view? Does the creditor have more debt capital invested in the company than you do via your smaller equity position? What is the debt-to-equity ratio? Is it less than 1-to-1? The creditor has a bigger stake in the company than you do, dollars financing the assets. Be a little more sensitive and cut out any fighting back and forth, okay? It's never too late to apologize for your behavior if necessary. You have to go into this realizing that you may need to build a stronger bridge across what you think is a grand canyon that may exist between you and your creditor. Make certain you're well prepared and understand how to use the right tools so you don't stumble or even fall off a cliff. So what steps do you take? Conferring with legal counsel is always something to consider and recommended. Know your cash position and forecast ASAP. Assuming you will take some time and understand the creditor's perspectives and positions, the most effective tool you can use in crafting a repayment solution, besides all the required reporting that you need to do, is the pro forma cash flow statement. Google up pro forma cash flow statement for yourself if you need to, or talk to your accountant, and get to work on preparing your own. You or your CPA need to prepare a pro forma cash flow through the rest of the current year and all of the following year, month by month, to show how you intend to stay in business. Show what cash flows will be generated and used to repay your debts as much as possible. Refresh the statement every quarter if necessary, or each month if warranted. And be honest and do your best. All anyone wants, any creditor, any bankruptcy judge, any attorney, is for you to be honest and do the best you can in repaying your debts as soon as it is reasonably possible. What more can be done or asked of you? So, with overloaded bankruptcy courts and asset quality in the tank for many creditors, you must step up. This is your time to step up big time. Avoid any contentious situation with your creditor or creditors, and use your pro forma cash flow statement to show the creditor exactly how and when you will repay your debts. If you find yourself getting heated and frustrated, step back, take a breath, but don't go there again. Ask questions, listen carefully, and rework your pro forma if possible or needed. You will likely be very successful and will likely avoid having to go bankrupt. Thank you for joining us. Today we covered the creditor tool Bankruptcy as debtors prepare to propose their own repayment solutions. We want to hear from you. Share your own credit risk memo and debt repayment experiences, questions, and recommendations with us at NACARA.org. If you found today's episode helpful, please subscribe for notifications of future podcasts. Your feedback helps small businesses stay in business. Till next time, step forward and take responsibility for your own debt repayment solutions. Thanks again.